Hi, and welcome to our third and final webinar in preparation for our live workshop event that's coming up in a few weeks. Our silent bystanders contributing to the harassment epidemic. Dr. Larry, would you like to provide an introduction on today's speakers?
Sure, really like to do that. I'll introduce myself first, reading from my bio here. Striving to traverse that intersection between contemplation and action, engaging in lifelong education has always been Dr. Heiner's way, while continually building, modifying, reiterating, changing, and, well, acting. His formal education, culminating in a doctorate in organizational psychology, is complemented by perennial immersion in professional training and conferences. His 40-plus years professional experience have kept all of this acquired knowledge in meaningful play. Dr. Heiner's latest pursuit is as co-owner of Workforce Equanimity. To be an effective workforce, all must be enabled through persistently mindful preparation to learn, think, and act with intention in an environment that honors human dignity. It's always interesting talking about oneself in a third person. So I'll move on to Lawrence. Lawrence has 15 years of experience in designing and facilitating workforce development programs. His clients include Verizon Wireless, major grocery retailers, and the state of California. Recently, Lawrence has spent time connecting with the employee behavioral elements of solving the sexual harassment epidemic with the legal training that exists and is evolving. We also have two attorneys on the call today, Sejal and Tim, and let me introduce them. Sejal Friday possesses litigation experience in employment-related matters with an emphasis on wrongful termination, sexual harassment, discrimination, and retaliation cases. She counsels management, human resources personnel, and employees on all facets of the employment relationship. She also provides workplace civility training that focuses on promoting respect and civility in the workplace, along with focused training on eliminating unwelcome or offensive behavior that is based on characteristics protected under the anti-discrimination laws. Also with us is Tim Del Castillo, and Tim practices employment law litigation, providing strategic and preventative advice and counseling to employers and executives. His time with international law firms and representing large institutional clients provided Tim with unparalleled training and experience in navigating the often complex world of California and federal employment laws. What he enjoys most about his now independent practice is helping individuals and smaller business owners for whom employment-related legal issues often hit closer to home. So today we're going to actually be talking again about two sides of this issue around bystander, both from a cultural, psychosocial standpoint, as well as from a legal procedural standpoint. And Lawrence, I think that you're going to get us started on this conversation.
Yeah, the last couple of calls that we had, we talked about what's gone wrong with the sexual harassment training in the past and what leadership can do about it. Today we're going to talk a lot more about what the EEOC has put out in terms of guidelines for a culture of civility and some of our approach to meeting those guidelines. This topic is something that has been studied, is being studied at the moment, when EEOC published their guidelines, they acknowledged that creating a culture of civility is a way of enhancing what is already out there in terms of compliance to what companies can do to solve problems in and around sexual harassment and when they need to bring those problems into a courtroom. So later today, or on this call, we're going to take a look in a little bit more detail at what EEOC recommends and then how we're going to approach that. Now, Dr. Larry, let's start off with discussing some of the barriers that people are facing in creating that culture.
Sure. There are barriers, and they fall into different kinds of buckets. Christy Sim, Dr. Christy Sim, Christy, last name Sim, Sim, in December of 2015, actually posted a blog and a PDF about this. She had done some literature review about the different kinds of reasons why people are not intervening when they're bystanders and they see something going on. So that's at the core of what we want to talk about today. On the screen, you see that there are 5 of the things that she calls out from her literature review. The first one is about social influence as a barrier to intervention. When you look around you and you say, hey, nobody else is saying anything, or nobody else is picking up that trash, or nobody else is doing that, so it must not be a norm here, then that keeps one from going ahead and doing that, picking up and rinsing out that coffee cup, or reporting that someone is acting inappropriately in a sexual manner towards someone else, or telling off-color jokes, or whatever the behavior is. They're constrained because they don't see that it's a norm here. The second is audience inhibition. So you might be afraid of embarrassing yourself by coming out and saying something, like if you're the only one. This kind of follows on. And these, by the way, are not exclusive sets. You don't fall into just one. We all fall into multiples of these. But this one about audience inhibition is, hey, you're with your coworkers, or you're with maybe your friends, and calling somebody out could be a socially embarrassing experience. And that's what she means by audience inhibition. We just don't say something because we may potentially be embarrassed. Third, she mentions diffusion of responsibility. Now, this is what we do a lot in a lot of things. And we assume that somebody else is going to act. There are some really wonderful videos on YouTube about social experiments where people will just pass by, kids freezing in the street and not do anything because they think, I guess, somebody else is going to do something about this. Someone else will give that person their coat. Somebody else is going to report to management that this inappropriate stuff is going on in our workplace. And so that diffuses the responsibility across the whole group, the whole organization. There's also a fear of retaliation, and Tim's going to talk about that here in a little bit from a procedural and legal standpoint. But that fear of retaliation is real. To think that if you report this, then either that person or somehow your management is going to make it more difficult for you at work, possibly even getting fired or getting reassigned or getting less desirable assignments, and also just being frowned upon and looked upon poorly, having a lower rating during performance review time. Those kinds of things may occur, particularly if the perpetrator is the person who has that power differential and is the manager or supervisor. That may put one in a difficult situation reporting. So the fear of retaliation is real. One of the last categories that she talks about here is called pluralistic ignorance. It's kind of like a social influence that's so embedded that people just don't see it as being wrong. That, hey, this happens in the workplace all the time. There are workplace flirtations. There are people who act in particular ways. This happens all the time. It's part of it. The movie industry, for instance, has seen a lot of that. Talk about the casting couch. And it's accepted as, in a way, as part of, as a norm in that particular culture. Now, the Me Too movement has been coming out and now calling it out and saying, no, that wasn't appropriate then, it's not appropriate now, and we just weren't calling it out. But that's an example of the pluralistic ignorance where everybody sort of agrees that this is the social norm and nothing is wrong with it. So those are some of those areas. And Tim, I think you're going to go into some of the aspects of retaliation, particularly now there's some reinforcement to those laws that are standing out there on the books, and they're the ones that are existing.
Yeah, thanks, Dr. Larry. Dr. Larry addressed the barriers to intervention generally, social influence, audience inhibition, diffusion of responsibility, fear of retaliation, and pluralistic ignorance. And it's important to recognize there's not just one barrier to intervention, but I'd like to focus our attention on one of those areas where employment policies can really have a significant impact in reducing one barrier to intervention, and that's fear of retaliation. Now, legally, retaliation is defined as an adverse employment action that happens because of protected conduct. Generally, that's how it's defined. And certainly reporting sexual harassment against oneself or others is an example of that kind of protected conduct. Now, retaliation is a real problem in workplaces today. How do we know that? Retaliation happens. As you see on your slide, the EEOC and the California Department of Fair Employment and Housing have published statistics showing that retaliation is actually the most common claim filed with those agencies. It's more than discrimination, more than harassment alone. According to the EEOC, the number of retaliation charges it receives annually has tripled over the past 2 decades. In fiscal year 2009, since 2009, retaliation has been the most common claim alleged with the EEOC. In 2016, retaliation charges represented a whopping 46% of the total charges of discrimination filed with the EEOC, up from 15.7% in 1993. And from the Department of Fair Employment and Housing, which again is the state counterpart to the EEOC, retaliation is also the most common basis for retaliation or for charges that are filed. Now, by the law of averages, we know even if not all of these claims are meritorious, and some would say, well, that just means somebody filed a claim. It doesn't mean there's any merit to it. That's true. But if this is the most common claim that's being filed by the law of averages, we know that retaliation must actually be happening at an alarming rate. So on the one hand, employees' fear of retaliation if they engage in bystander intervention is a legitimate fear. There's retaliation happening. But for those participating in this call, we know we're good employers and we don't retaliate. So the question is, how do we let our employees know that we're a supportive employer? We are not a place where employees need to be fearful of retaliation if they engage in bystander intervention. Well, fortunately, the EEOC not only gives us helpful statistics, but they give us some guidance. On August 29th, 2016, pretty recently, the EEOC released its new enforcement guidance on retaliation and related issues. In that guidance, the EEOC provides some promising practices. The guidance replaces the EEOC's 1998 compliance manual section on retaliation, and it provides the EEOC's interpretation on retaliation under the statutes enforced by EEOC. It addresses case law developments since it issued its last guidance. You can find the full report on the EEOC's website, and I've highlighted on the slide here for our discussion some of the key promising practices that EEOC provides employers for preventing retaliation. 1, maintain written, plain language anti-retaliation policies, kind of a no-brainer starting point. 2, provide training. Don't just have policies, actually engage interactively with your employees. 3, following any equal opportunity allegations, provide anti-retaliation advice and individualized support to managers, supervisors, and employees. I'll tell you, sometimes in cases I've been involved in litigation, I see a complaint of harassment, and you'll see the email from HR going to the alleged harasser saying, you've been accused of this. By the way, you know, we have an anti-retaliation policy. Okay, well, that's good as far as it goes, but I cringe when I see that sometimes, because it makes me think that if there's not more than that simple reminder going on, not enough is happening. You need individualized direct support. You should be having a one-on-one meeting with that alleged harasser, making sure that they understand what it means not to retaliate against the complainer. 4th, proactively follow up when an EEO matter is pending to identify retaliation concerns and provide guidance, again, along the same lines I just mentioned. Review employment actions to ensure EEO compliance. Before you demote the person, before you terminate the person, make sure you understand all of the risks if this is an individual that has made any kind of protected complaint.
So Tim, this is Dr. Larry. I have a question. A question came to mind while you were talking, particularly about the last slide and the frequency of reporting. And by the way, for our listeners, you can, if you have any questions, you can type them into the chat window, and we're monitoring that chat window, and we'll get to those at the end of the presentation. We have a Q&A session. But my question, right? I was wondering, you're saying that the reporting is accelerating, that it's growing, the reporting. So do you, and maybe Sejal, you may want to weigh in on this as well. Do you see that, is it because the laws and procedures are getting better about protecting people against retaliation, and so they're reporting it more frequently, or it's more of an awareness, or it's just part of the overall sort of pushback on this, the Me Too and the stand-up kinds of things? What do you see as kind of contributing, maybe it's all of them, I don't know. What do you see as contributing to this increase in reporting about retaliation?
That's a really good question. And just a couple observations from my own experience, and I'll share, in my own experience litigating cases, defending and prosecuting cases of retaliation. It is a very common claim, and I do see it come up more often than a straight harassment or discrimination type of claim. I think there's a couple reasons for that. One is that the legal standard for proving retaliation is a little bit easier. The reason is when you have somebody who complains about something that they believe is illegal, that they believe is harassing, and you retaliate against them, that's a violation of the law, whether that individual was right about what they believe to be unlawful. So in other words, a reasonable belief that a legal violation occurred is sufficient to establish a cause of action for retaliation, whereas it might not be sufficient to establish the underlying harassment or discrimination or other legal violation. The other observation is that you asked if the laws are expanding, and they are in this area. There's labor code protections for retaliation. There's protections for retaliation in Title VII, in the Fair Employment and Housing Act. And not only is the case law expanding protections for retaliation, but some of the statutes are also being amended to expand. For example, I'm thinking of the labor code protection for retaliation, which as of 2014, not only applies to external reporting of legal violations. So if I went to the government and report a legal violation, but it now also applies to internal reporting. So all I have to do is report to somebody who has authority over me, hey, I think this is going on. And if I'm retaliated against because of that, that's a legal violation now under the labor code. So I think these are good developments. I think certainly the Me Too movement is also a good development insofar as it's encouraging people to come forward. because, as I mentioned, I am seeing an increase in retaliation claims, and there are a lot of them. I still also hear about individuals who do not want to support because of fear of retaliation. I have a case recently with, looking at some documents, and understandably that an individual is saying, I believe what happened to you, I understand, but you also have to understand that I have bills to pay and I can't risk losing my job.
Right.
So that fear is there, and I think that we can do more on our part as employers to encourage employees to come forward and to not have that fear.
Yeah, a lot of what you're talking about there is the leadership issue that we discussed on our last webinar on this as well. Refer our listeners back to that. You can listen to the recording on that. A lot of these are leadership issues, and setting this very clearly. Thanks, Tim.
Yep. So the next issue for us to address for bystanders is why the bystander might ask herself or himself, why should I come forward? Well, first and foremost, it's the right thing to do. As employers, we need to be proactive. Again, don't just put in an email, we have a policy against retaliation. Be proactive, train employees, remind employees. And another issue that I see is we need to make sure that we're not prioritizing profits over people. This can happen when you have a harassing manager or supervisor who is particularly valuable. They're a rainmaker. And for that reason, their incivility is tolerated. I think this is a big mistake. It may seem in the immediacy to increase the company's profits. We can't get rid of this person because they just bring in so much business. But if that's the priority of your company, in the long run, you're really going to suffer not only cultural consequences, but financial consequences too, I think, if you allow that kind of a toxic environment to be tolerated because of priority of profits.
Yeah, we talk about the cost of turnover, for instance, and if that individual is causing turnover in that office, that's going to cost them a whole lot more than whatever that person's bringing in, really. So you're right, having that toxin in the well is going to have even further impact, financial impact on your organization. So you really do have to look at it. It's not just the right thing to do. It will be actually the economical thing to do, even though it may not look like that on the front of it. So we want to, as it says on the screen there, we want to foster a culture where the dignity of everyone, and whether we're talking about employees, customers, supply chain people, whatever, but certainly the employees' dignity is valued, and where people look out for each other. If you have an organization that has transparency, has been trained up in emotional intelligence and ways of communicating with each other effectively at that level, you have the transparency, you have trust in the organization. People will call these things out much earlier, before they get to be a real problem. As soon as they start seeing on the horizon that this behavior isn't appropriate. So say, somebody's starting off with an off-color joke, and it's not called out, and then that person takes that as a tacit approval to continue with other kinds of behaviors that eventually then lead to something that's more major. Well, if it's called out in that early stage, if people feel really respecting each other, transparent, equipped with emotional intelligence training, then they will be able to call that out a lot sooner and be able to identify that individual. Maybe that's not a good fit for that team. Maybe the person just goofed and mistook, reading the group, that they would appreciate this, particular kind of a joke. Whatever that is, at least it can get talked about at the group level before it even bubbles up into HR and an issue and the courts or litigation. Not trying to put you out of a job, Tim and Sejal, but if we could deal with it at that level, a lot less floats up there. What do you think?
I think that's right, Dr. Larry, and I do not begrudge you at all for putting us out of a job, and unfortunately, that's not going to happen anytime soon with the way things are going. But we need trainers like yourself to help employers with these culture and civility issues.
Well, supposing it does actually get to the point where an investigation needs to take place, it could be, and perhaps we're saying it should be, held in the workplace itself. And Sejal, I think that you've got some ideas about how people would proceed to conduct this kind of an investigation in the workplace before it would even get to the courts.
Sure. Thank you, Larry. Absolutely. I don't think we're going to be out of the job, unfortunately, because of everything that's going on. This area that I'm going to be talking about right now is very important. And as you can see on the slide, there's a lot to cover. And obviously, during a webinar, a short webinar like this, we can't get through all of it. But I wanted to just quickly highlight that, failure to conduct investigations or doing haphazard investigations can have dire consequences for the company. And you see here that I've identified 10 elements that have to be considered when an investigation is happening in a workplace. And all of these issues we're going to talk about in detail at our live presentation coming up in March, which I'm hoping everybody will attend. But really quickly, let me just say a sentence or two about each one of these. And again, at the live presentation, we're going to really break these down. The first one I have here is obviously just failing to conduct an investigation promptly. All complaints that come in regarding misconduct, whether it's harassment, discrimination, bullying, or any other type of inappropriate misconduct, should be taken seriously. And we know that any kind of delay that occurs in starting the investigation can cause disruption in the workplace and also result in some evidence getting lost or forgotten with the passage of time. So we want to make sure we respond promptly to any complaints received. On the second issue here, procedural fairness, we want to make sure that the investigations are fair for both sides and that the findings are unbiased. One of the things that I saw when I was conducting workplace investigations at UCSF is that we want to make sure that you have investigators that are neutral and that can listen to both sides and issue a unbiased finding. So going along with number 3 here, we want to make sure we're selecting the right investigators. And this is going to depend on, do we have an investigator that we want to take from internally, or do we want to have an external investigator come in? And again, this is going to depend on whether the case is complex and whether there is an issue of conflict of interest arising. Next thing we want to look at is, is the investigator going to be able to conduct a unbiased investigation? And what I mean by that is, are they going to be able to handle issues that come in with the degree of sensitivity and expertise that's required? Transparency is another key component that we want to look at regarding whether the investigation is going to be biased or unbiased. The next thing we want to make sure we do is that we want to make sure we gather all of the relevant information. And what I mean by that is, are you interviewing the right witnesses? Are you gathering all of the documentation? Are you making, sufficiently detailed summaries of all the evidence that you can make a really good credibility assessment of all of the evidence obtained by the investigator? And one of the things that I want to do at the live presentation is really give you some good tips as to how you make a good credibility assessment. There's a lot of different factors we look at. And in fact, we'll be doing a case study to highlight how you can make a good credibility assessment. Also, with regards to confidentiality and privacy concerns and retaliating against the complainant, and then advising parties of all the remedial steps. I'm going to be talking about all of these issues on the next slide. But the key issue here on this slide, the last thing I want to point out is we want to make sure, and you hear, HR folks and attorneys saying this all the time, document, document, document. Proper documentation is essential to ensure that the evidence is accurate to support the findings. And when we get these cases in court, how the investigation was conducted is really a key component to how the case is going to turn out. So if we can go to the next slide, some of the elements that we look at with regards to what are, some of the issues, what are the fallouts from these investigations? Because obviously the investigation completes, but then everything else is disrupted. So we want to make sure that we ensure that the parties that were interviewed, not just the respondent or the complainant, but all of the parties have some level of confidence that their concerns will be kept confidential. Now, we all know that we cannot guarantee anybody 100% confidentiality, but there has to be some respect for the sensitivity of the information and the documentation and the other evidence obtained during the investigation. Also, anti-retaliation. Tim did a really good job at highlighting all of the retaliation issues that arise, and these all apply to the investigation setting. All employers have an obligation to ensure that there's no retaliation against complainants or others who cooperate with the investigation. And then lastly, we want to make sure that after the investigation is done, that we notify the complainant and the respondent of what will happen next. And then it doesn't end there, because there's witnesses that were interviewed, and they also should be contacted and warned and advised that if there's any sort of retaliation that occurs towards them, that they should notify the appropriate parties. All in all, when it comes to investigations, there's a lot of information. Some of the other mistakes we see in the cases that I reviewed in preparation for this webinar is that, sometimes the investigators will apply the wrong standard of proof. So we'll talk a little bit more about these other issues, along with how you can properly make sure that you're securing the evidence, because how we do investigations now as compared to how we've done them in the past has completely changed. So I'm going to walk you through the steps that you can take to make sure that you're properly securing the evidence when we get to in preparation for trial. So Lawrence, where do we go from here?
Well, that's a great question, Sejal. I think at this point from this call, it's pretty clear that if you haven't done these things yet, it's important to start looking at them. So start looking at how the company can update its policies to reflect workplace harassment and discrimination reporting protection, making sure that those employees know that they're protected and how. Set clear guidelines for information to gather during investigations. And Sejal, you did a fantastic job of how to avoid those pitfalls and what to do. I know that at the workshop, we'll be going through that as an activity. So if you're having difficulty there, please do join us. If not, take a stab at this ahead of time. And then the third thing is to provide and communicate ways for people to report misconduct. It is not enough just to have a good supportive structure in place, but people need to know that it's there. So find a way to encourage people to step forward. To play this all out in workshop mode, please do join us. We're going to be live in Sacramento and in Oakland coming up in the next few weeks. And you can find registration for that event at workforceeq.com/events/CultureEQ 2018. We'll have links in the notes here. And then those registrations go through Eventbrite. So you'll see them popping up in Eventbrite. And as we wrap up, do we have any final notes from our speakers before we wrap up? And then after that, we'll take questions.
I'd just really like to thank Tim and Sejal for working with us, Lawrence, and putting this together and really bringing both the sort of psychosocial cultural aspect along with the legal procedural aspect, both in the workplace and in the litigation mediation environment, so that we have this complete spectrum of a view of something that's emerging as a very serious issue in the workplace today. So Tim and Sejal, thank you very much for joining us.
Thank you, Dr. Laird. It's really been a pleasure working with you, and I agree with you 100% on the synergies we're able to create with the psychosocial and legal perspective. I think it's important that employers in today's day and age, in today's environment, take a holistic approach in trying to solve this issue.
Absolutely, and I'll just add the same thing. I think that we all know that training can't be a canned, one size fits all, check the box type of training. It really has to be tailored to the specific realities of different workplaces. And I think it really takes a team like us to be able to go in and assess the environment, to make the appropriate recommendations and provide the training necessary to change the culture and make it a culture of civility. So thank you very much for inviting us to join you on this crusade.
We're excited to be part of this team and looking forward to conducting the workshop here in the next few weeks when we get a couple of things nailed down for date and place. We're definitely going to get that information out via LinkedIn and Facebook and our webpage and Eventbrite. So stay with us on that. Are there any questions that people have?
Yeah, we've got a few questions, so we'll take those now. Well, we've got at least one question in any case that came in. How do I know when I need to do an investigation? What if the complaint is really minor and I really just, or maybe it's just a coworker being a jerk? So how do we know? Maybe that's a good one for either Tim or Sejal.
I'll throw in my 2 cents. I would say, you do want to err on the side of an investigation. Every situation is different. It's really, I think you would need more details in terms of how minor is this incident. I also understand the concern that an employer and HR professional might have about launching a full scope investigation when you have, my boss is being mean to me. There's not really any indication of sexual harassment going on. We do have to be careful about workplace bullying too. That's becoming a hot topic. And so I'm reluctant to say, well, yeah, you don't need to do an investigation if somebody's just saying their boss is being a jerk. I think at a minimum, you need to look into that and maybe determine if a full scope investigation is necessary.
You bring out a good point, Tim, in that when we're assessing those behaviors, sometimes that behavior would fall into a camp of the person just goofed, and we can correct that within our group. We can address it, and we can call it out. If we're a secure group, emotionally intelligent group, transparent group, we can call the person on that and just kind of deal with it at that level. The same behavior in another situation where people don't have that may, as you say, need to really be identified and reported before it gets too serious, even though it may be seen as minor. So I think in addressing the person who had the question.
The one final question that we had was what are some of the things that are going to be discussed at CultureEQ? And we do have a couple of points of interest at CultureEQ. That is the live event that we've been talking about. From the training side of the house, from the regular employee training side of the house, we'll be providing a blueprint for shaping intentional cultures. We'll be looking at proven strategies for building cohesive teams. We'll be talking about how to connect emotional intelligence with effective management and productive conflict. And then we'll also have a sample training tool bundle that's valued at over $200. So look forward to some of those things. On the HR legal side of the house, we've got we'll be discussing how to comply with the EEOC's guidance regarding sexual harassment investigations, like Sejal was talking about earlier on the call here. We'll be providing a blueprint for conducting workplace investigations. And then we'll have a training compliance checklist for you as well. So look forward to those things. I think that wraps up our questions for this call. And we look forward to seeing you at CultureEQ 2018.